Welcome back, team. This is third video. We've established some stuff about Kennedy, his kind of thousand day presidency, and then from there we talked about Johnson's Great Society. And today we're going to try to better understand some of the physical things that go into shaping this great society of, as he called for, racial injustice to end, for poverty to be abolished, and so forth. So the first part of our conversation today won't bring up Johnson so much, but the Supreme Court that operated during his presidency. It's called the Warren Court, after Chief Justice Earl Warren. That's actually kind of why we have the target spaced the way we do with the Warren Court. Now, Supreme Court, one of the leaders of the three branches of government, the judicial branch, traditionally 9 people on it. This court, like many others, is 9 older white men, but they're actually going to be surprisingly liberal, and by that we mean they're going to advocate for a lot of change in civil rights. A lot of things that we might take for granted today, we actually owe to the Warren Court for making kind of in law. So as we're going through this, I've tried to change the file formats for a few things to make them a little more accessible to you. So let me know if that's helping you out. I might try to make them more Google Slides whenever possible, or Google Docs when possible. That's not always possible, but I'm trying to do what I can. So if you want to have the Warren Court reading up, we're actually going to be looking through this reading a bit to try and better understand some of these cases. So a Supreme Court case usually establishes what we call like precedent, right? As far as what you can and can't do. So these 9 guys, named after the Chief Justice Earl Warren, are going to really go into a bunch of cases that modify how we view our rights. So we could talk about this forever, but we're going to focus on 3 in particular. The first being your Miranda rights. Hopefully you have never heard these, but it's really the informing you of what you can and don't have to say while being arrested or charged. As with all these cases, it's named after the man Ernesto Miranda, who was not informed of some of his rights. In particular, the rights remain silent. So he argued that since he had spoken without being informed of his rights, he was actually being denied his liberty. And the court ruled in favor of him. That's why we have what we refer to as our Miranda rights now. When you're arrested, you have the right to remain silent. Anything you can say and will be used against you in a court of law. You have the right to an attorney present during questioning. If you cannot afford an attorney, one will be appointed for you. All that fun stuff. There's the great scene in, I think it's 21 Jump Street, where they mess up the Miranda rights and they have to let a guy go. And there's obviously stipulations here, but at least the fact that when arrested, you need to be informed of maybe your civil protections against yourself. That's a big step, and it's really kind of put into precedent by the Warren Court. Here's a little video if you're having some trouble with the reading to understand the Gideon Wainwright case. It's pretty good. It's rather short. You should hopefully be able to play it. I know some of the YouTube things have been restricted, but regardless of if you can't see this, the reading should still cover it. The topic really in question is all about representation. This man over here was unable to afford an attorney, and he was being charged with robbery of a restaurant. I believe it was a bottle of wine and some cash. And when he asked for a lawyer to represent him, the judge said, no, you're on your own. And he actually brought this all the way up to the Supreme Court, which they did find, he was right, that regardless of if it's a murder case or a simple shoplifting case, you have the right to some kind of attorney to represent you, to help you out. And we still have that today. We have public defenders. Now, this is by no means a perfect system. This is data for Missouri public defenders. The blue is the recommended amount of time an attorney should have to conduct a case, and the red is the actual time that public defenders have. And as you can see, the amount of attention you get is very limited. I mean, juvenile cases, you have almost 20 hours. Public defenders traditionally got like almost only 5 for you. Murder cases, right? Up and down across the board, it's kind of alarming how overworked these public defenders are. And when I say overworked, this data promotes that idea as well, right? You should have recommended around 125 misdemeanors per year, and actually you get close to 200. And if you are a really good lawyer, right, someone who wants to help, everyday people, the money's not quite there for you either. So the red is public defenders, and the blue is pay and, being a prosecutor. And clearly, if you're following the money, a lot of the talent pool will be pulled away from public defense. And it's kind of alarming when you start to think of how many people then are forced to take plea bargains and so forth. But hey, it's better than not having a lawyer, right? In our last case, Escobedo versus Illinois, shout out to Illinois, this cartoon does a good job of showcasing this case. You see the man behind bars here saying, "I want my lawyer," and the police officer saying, "Sure, we'll get you, but we want to first have a little conversation with you." And this is something that Escobedo versus Illinois would decry as unconstitutional. This case makes it very clear that when you say you want your lawyer, you get your lawyer. Even if you haven't been charged with a crime, simply questioning, you still have the right to kind of hit the timeout button, converse with counsel, and kind of come up with a game plan, even if you haven't been charged with it. So if we're talking about a legacy of the Warren Court, you would want to think of it maybe as a very liberal legacy. And by that we mean it did a lot to promote civil rights, civil liberties. Like these cases give you the right to understand your protections under law when arrested. It gives you the right to an attorney. It gives you the ability to converse with your attorney even during questioning. These are all aspects that push to try and keep you civilly protected. And we've talked about the Supreme Court before in our class, back from Andrew Jackson ignoring the Supreme Court's Indian decisions for removal to FDR trying to pack the Supreme Court. So it's not the first time we've heard of it. But we're going to keep kind of talking about legal changes here, and let's talk about the Civil Rights Act of 1964. So you can actually open up a second document for this, and we're going to talk about some legal changes that are happening under Johnson's Great Society. We'll spend a lot more time later this week talking about kind of the ground movements that force these changes, the actual kind of the blood and sweat people had to shed to get to these moments of victory. But we're going to start first with the legislative changes. Who you see on the left here is Lyndon B. Johnson, president, signing this act into law. You can see the pens there. He's handing them to Martin Luther King, someone we'll talk a lot about in terms of his advocacy for civil rights. But let's try and break it down in kind of 4 provisions, or 4 sections, if you will. The first bans the use of voter registration standards that differ between races. And this is something that alarmingly continued. If you remember in Reconstruction, we passed that 15th Amendment. It says you should be able to vote. Yet, countless little stipulations or Jim Crow laws or black codes were passed, predominantly in the South, to deny those constitutional rights. ID voters count as that too, but we've had this conversation. Don't worry about it. Remember, we even took one of these literacy tests, right? That would not be given to everyone. And clearly this was an attempt at limiting people's voting opportunities. So those, provision 1, are gone. Provision 2 prohibits discrimination in public accommodations such as motels, restaurants, gas stations, etc. This has come up actually rather recently when you talk about gender equality with bathrooms. But yeah, as far as segregation in public facilities, this tries to end that. Provision 3 says if you are, in particular, here's the important part, a private program that tries to continue discrimination like a private school or anything, you will get your funding cut off. As we'll see throughout history a lot a lot of time change doesn't quite occur because people realize it's morally the right thing to do. Oftentimes hitting someone's wallets is the best way to create change. And that's what this provision is trying to do. Withhold money or funds from private institutions trying to not change. And lastly, it banned discrimination of employment on union membership by basis of race, sex, religion, national origin, really trying to zoom in on employee practices that had been going on for a long time. Unions trying to limit who they allowed in or offices or works, hiring only a certain type of people. Provision 4 is trying to ban these things. Now, while all this may seem like, oh, Civil Rights Era, 1964, this is the culmination, it unfortunately will be not. Just because something's placed into law doesn't mean it's placed into action. And we'll be learning the next week or so about how just because these things are written down and said doesn't mean they go into full effect. That being said, there's two other kind of laws that changed that we want to look at briefly. First being Immigration Act in 1965. As you can see here with our data, it's going to really push this shift in who's allowed into the country. Like, look what happens from Europe from the 60s to the 70s, 53 to 18. Asia goes from 6 to 35. Latin America, 25, 40. We're trying to finally fix some of those kind of imbalances in our immigration policies. We had constantly favored European countries we knew, and now we're changing those quota systems to try and let in people from different areas of the world. And lastly, the Voting Act of 1965. You might be, wait a minute, didn't we have the 15th Amendment and just have the Civil Rights Act in 1964? Why is there another voting thing? Well, unfortunately, we needed it because as this law is going to affect, you had 6 African Americans in the House, no one in the Senate. But 6 years later, you have 13 in the House, 1 African American in the Senate. While still very low numbers, that's a monumental increase. So what changed? Well, the Voting Rights Act banned those literary tests, provided federal oversights if you had 50% non-white population not registered to vote. So basically, if something looks fishy, why aren't people voting? We're going to go investigate it. And this is a great example of how just passing a law isn't quite enough, that sometimes it takes additional measures to try and enforce and keep, people's protections in place. While these conversations have all been kind of big picture court cases and Supreme Court decisions and legislative laws, the next few days we'll be talking more about the people who are really advocating for these changes and trying to make sure they happen once they're passed. So we'll be talking about that next. Again, as always, please let me know any questions you have.